It's certainly the big story of the morning. The Constitutional Court ruling that former President Jacob Zuma is not eligible to stand for this month's election. The court has just delivered judgment in the Electoral Commission's appeal of the Electoral Court order that allowed Zuma to remain on the uMkhonto Wesizwe Party candidate list. Now, the Commission approached the Apex Court to seek clarity on the interpretation of a section of the Constitution that relates to grounds on which people are eligible or not to stand for the polls. Let's continue with our reaction. Get in now the Council for the Advancement of the South African Constitution's Executive Secretary, that's Lawson Naidoo. CASIC, of course, being admitted as a friend of the court in this matter. Great to have you on the program, Lawson. Thanks very much indeed for making time. And part, I suppose, of the point that CASIC was making is that the debate around the remission of any kind of ruling should not have a bearing on the separation of powers principle, so to speak. I'm sure you'll put it in a much simpler way, but you're certainly vindicated given this ruling.
Good morning, and thank you so much. Yes, I mean, we welcome this judgment, and I think it's an important day for the rule of law in South Africa. This was a clear, concise judgment from the Constitutional Court, importantly, a unanimous judgment on an issue that had raised, considerable division and diversity of views on it. But I think, our view was always that a plain reading of Section 47(1)(e) of the Constitution, the disqualification provision, was quite clear that somebody like Mr. Zuma, who had been sentenced to imprisonment for more than 12 months, was not eligible to stand for office. And I think in Justice Theron's summary this morning, she spoke importantly about looking at what is the purpose of that provision of the Constitution. And it is to disqualify people who have been subject to such sentences. So the arguments that CASIC made, together with those that were made by the other parties, obviously including the Electoral Commission, were all found in favor by the Constitutional Court. The issue you raised about remission was one of those, but also the fact that even though the conviction and sentencing by the Constitutional Court was not subject to appeal, it was a final judicial decision which brought into play the provisions of Section 47(1)(e).
Yeah, another major point of discussion was around sentences imposed versus sentences served. The Constitutional Court here finding that this particular provision of the Constitution actually refers to a sentence that is imposed. So even if there were to be a remission, anybody who has been sent to jail for more than 12 months would be disqualified as per the prescripts of Section 47(1)(e).
Yeah, and I think the important point here is that, the sentence that is imposed by a judicial authority, by a court, is what really matters here. The remission of sentence is done through executive action, and that should not have an impact on a judicially imposed sentence. So the sentence imposed as opposed to the sentence served is what matters in this regard. And again, in Justice Theron's summary this morning, she was very clear on that point. Obviously, we're all waiting to see the judgment in full, but I think this is, as I said, an important day for the rule of law in South Africa and for clear judicial reasoning. And I think we must also pay tribute to the Constitutional Court for handing down a full judgment, a mere 10 days after hearing this matter.
Yeah, and it was a unanimous judgment at that. We're also hear what the Constitutional Court would say around the powers, for lack of a better term, of the IEC. I mean, part of the arguments that were being advanced here is that the IEC, in fact, overreached. They went too far by deciding on the eligibility of any candidates for the National Assembly. The court disagreeing with that, saying actually a strict reading of the Electoral Act points us to the fact that, in fact, the IEC is empowered to make the kind of findings it did.
Indeed, and I think that was important because, in a sense, that was the clarification that the IEC was seeking in this matter, although, the application of the Constitutional Court was ultimately based on an appeal of the Electoral Court decision. But this clarification of the power of the IEC is important because, they're an electoral management body, and, the determination of candidate lists and the eligibilities of political parties themselves is something that falls within the remit of the Electoral Commission. And despite the arguments put forward by the MK Party and Mr. Zuma, this is not a matter that can be deferred to to Parliament to deal with, because Parliament is at what point does would Parliament consider such an issue? Before members are sworn in? Is somebody who is potentially disqualified sworn in and then removed? It's quite clear that a simple reading of the legislative framework means that the IEC is empowered to take such a decision, and importantly, it must be determined before the election, so that when we as voters go to the polls on the 29th of May, we know exactly which candidates for which parties are eligible or are up for election, and can base our decisions accordingly.
Yeah. I haven't seen any reaction from the MK Party, at least not yet. But in a way, without being preemptive, one can almost kind of gauge what might be said. I mean, for one, part of what the former president has been arguing is that there is a, apprehension of bias, that's the term I'm looking for, on the part of the justices. They gave a unanimous finding to say, in fact, they don't agree with that. But at the very least, we've been in situations where there have been all kinds of allegations being hurled at the justices at the Constitutional Court, narratives being pushed that the justices are out to get the former president. I imagine there's going to be a whole lot of that kind of sentiment off the back of yet another adverse finding against the former president. How do you reckon we should be dealing with that, given just how important not only this case is, but the standing of the institution itself is?
Yeah, well, I think, we can certainly expect that there'll be a political backlash from Mr. Zuma, the MK Party, and their supporters to this judgment, raising all of the issues that you've mentioned, Ayanda, including, the perception of bias by certain members of the Constitutional Court. And they also dealt with the recusal application that have been brought by the MK Party today, and unanimously dismissed any perception of bias, and made clear that the court was not precluded from doing its duty in terms of interpreting an important constitutional provision. But we will undoubtedly see a backlash, and we must ensure that the importance of the rule of law, the important role that courts play in our system of constitutional democracy is something that is defended and strengthened. And I think the court today has gone some way, as I say, in a politically divisive issue, to come out clearly on the side of the rule of law, and they must be lauded for doing that.
Yeah, absolutely. No matter how you dice it, it feels like we're in uncharted, unprecedented territories. And so there is no overstating just how important what just happened actually is. Lawson Naidoo, thanks very much indeed. We appreciate your reaction. Lawson, of course, is the Executive Secretary of CASEC, who, of course, also accepted at Friends of the Court in this particular matter. Reaction, I imagine, is going to continue for much of the morning.